Now, when Officer Andruski appealed the district court decision about summary judgment to the Second Circuit Court of Appeals, there were two main areas of the case the court needed to examine: Soukaneh's detention and the search of his person and vehicle. We start with the detention. Andruski first argues that he did not violate Soukaneh's constitutional rights by handcuffing him and detaining him in the police cruiser for over half an hour, because the detention should be governed by the standards set forth in Terry v. Ohio. And Andruski possessed reasonable suspicion of criminal activity to make a lawful Terry stop. Ah, the infamous Terry stop, or as it's colloquially known, stop and frisk. If you're asking yourself, but did Officer Andruski do more than just stop and frisk Mr. Soukaneh? You are correct. Alternatively, Andruski contends that even if the detention constituted an arrest, he possessed the requisite probable cause based on Soukaneh's possession of a gun, irrespective of the facially valid firearms permit. In other words, according to Officer Andruski, the legal possession of a firearm is probable cause for a person to be arrested. Apparently, to Officer Andruski, the legal possession of a firearm is itself a crime. Those aren't my words. They're the words of Officer Andruski in court filings. We disagree, however, that this was a Terry stop requiring only reasonable suspicion, because the facts before us demonstrate that Soukaneh's detention was a de facto arrest for which probable cause was required but lacking. We further conclude that the detention violated Soukaneh's clearly established rights. Okay, the court disagrees that this was a Terry stop, which only requires reasonable suspicion of a criminal activity. I guess if the officer had run Soukaneh's license and firearm permit, found them valid and gone on his way, that would have been considered a Terry stop. That's not what Officer Andruski did. It has long been the law that an investigative detention must be temporary and last no longer than is necessary to effectuate the purpose of the stop. A reasonable officer in Andruski's position who had desire to check the validity of an individual's licensing information would know that the circumstances here could barely justify a Terry stop, let alone a prolonged, handcuffed detention. Officer Andruski did not follow the law. This detention was more than temporary, lasting longer than necessary to check Mr. Soukaneh's credentials. By placing Mr. Soukaneh in handcuffs and roughly placing him in the police cruiser for an extended period of time, Mr. Andruski violated both the law and Mr. Soukaneh's rights. This is not a case in which there were circumstances, however insufficient, to establish probable cause. That might suggest to a reasonable officer that there was something illegal about a suspect's possession of a weapon. Here, there was literally no reason to believe that Soukaneh's possession of the gun, whose presence Soukaneh freely acknowledged, and for which he provided a facially valid permit that Andruski had no reason whatsoever to believe was forged or had been revoked, was unlawful. In short, it appears quite apparent by both the actions and words of Officer Andruski that he arrested Mr. Soukaneh for the alleged crime of legally possessing a firearm. However, the record here, taken in the light most favorable to Soukaneh, supports a finding that the detention continued far longer than was necessary to effectuate any of Andruski's alleged reasons for his actions, legitimate or not, demonstrating that he did not conduct the stop efficiently or in the least intrusive way possible. In absence of facts suggesting some irregularity to justify the nature of the detention, the constitutional question and the unreasonableness of Andruski's actions here are beyond debate for any reasonable officer in Andruski's position. Even if Officer Andruski's reasons for detaining Mr. Soukaneh were legitimate, by not using the least intrusive methods to assuage his concerns, he not only violated Mr. Soukaneh's rights, but did so in a manner that is beyond debate.